I want to talk to you today about discovery in a Texas divorce or a Texas custody matter. Divorces and custody matters are types of lawsuits in the state of Texas, and because they are lawsuits, they're governed by the rules of procedure. Those rules allow for discovery, but many people don't understand discovery. They don't understand that it's available, they don't understand it when it starts happening, and they don't understand what's going on. So let's talk about that today. Let's talk about discovery. Discovery is the opposite of all the great TV shows that you see. When you watch a legal drama, what you're watching for quite often is what's called trial by ambush. Those make for the best TV, they make for the best movies. It's when the guy pulls out the evidence that nobody has seen, or when the witness starts saying something that nobody's ever heard before, and it creates a lot of drama, and it creates great movies and great TV shows. In real life, though, that shouldn't happen. In real life, trial by ambush should never happen in a civil case. To some extent, it may be able to happen in a Texas criminal case, but in a Texas civil case, trial by ambush should not happen. Why? Because of discovery. Discovery are rules that allow both sides to see what cards the other side has. Theoretically, by the time you get to court, by the time you get to trial, if you have conducted your discovery the way you want to, then you should know everything that the other side is going to say. And that's because you have all of these tools that can be used in discovery. There shouldn't be any secrets. There shouldn't be any surprise evidence. You should know what they're going to present, what they're going to say, and likewise, they should know what you're going to say and what you're going to present. If I've asked them to tell me what they're going to say, as long as I've asked it properly. If they don't tell me and then they try to surprise me in court, that's objectionable, and I should be able to keep that out of evidence. The court should never hear that and should not be able to consider that. So, what is discovery? Well, the main forms of it are written in the state of Texas. Normally, they are written documents that are exchanged between the parties. So there are typically 4 written forms of discovery and 1 oral form of discovery that are used. The first written form of discovery is called request for disclosure. The second is interrogatories. The third is request for production, and the fourth is request for admission. Those are not in any particular order. You can take those in any order you want, but that's the way a lot of people think of them. Those are the ones that are typically used, and you can exchange them a little bit in that order, but those are the ones that are typically used in that order. So request for disclosure is basically just a list of questions that are the very basic questions that everybody needs to know in every case. What are you basically going to say about me? What is your case about? What are you going to claim about me? What sort of invoices are you going to present if you're asking for some form of payment for something? Who are your expert witnesses? Who is there out there who knows anything about this case so that I can go talk to them if I want to? Those types of things are covered in request for disclosure. Interrogatories are much broader. Interrogatories are open-ended questions, or essay questions is the way I like to think about them. If you go back to your time in school and think about it, interrogatories, request for admission, and request for production are the 3 older forms of written discovery. Request for disclosure is a newer form. So the other 3 make more sense in terms of thinking through going to school. Interrogatories are the essay question. Interrogatories can ask you very broad questions and ask you subparts and ask you to explain a number of things in the case. If you're going to claim that I abused you, tell me every time that you're going to claim that I did that. Tell me every incident in which that happened. Tell me who was there. Tell me what was said. Tell me where we were and what was going on. Tell me what injuries you claim to have suffered. In detail, all of that. Those can be questions that are asked in interrogatories. Requests for production are asking the other side to give documents, to give tangible things. So it's not asking the other side to create something. It's impermissible to tell them in request for production, I want you to create a timeline of our entire marriage, or a timeline of all the times that you claim I didn't come to pick up our child, or whatever. You can't make the other side create a document, but what you can do is ask that if a document that is described as such exists, then you need to give it to me. Give me all of the text messages that we've had while we've been married. Give me all of the text messages that we've had in the last year. Give me all of the text messages that we've had while we've been separated. Or give me all of the text messages that you've had with your boyfriend or girlfriend while we've been married. Give me all of the love letters that you've sent to them. Give me all of the emails that you've sent to your boyfriend or girlfriend while we've been married, before we were married, while we've been separated, or whatever. Give me all of the documents for the hidden bank accounts that you have. Give me all of the documents related to the cryptocurrency that you have. All of those sorts of things are for requests for production. Requests for admission are a different animal. They're more like a true-false test that you had when you were in school. Admit or deny that this happened. Admit or deny that you abused me on this date. Admit or deny that you hit me on this date. Admit or deny that you have a boyfriend or girlfriend. Admit or deny that your boyfriend's name is John Doe. Admit or deny that your girlfriend's name is Jane Doe, and on and on and on. Those things can be in request for admission. And request for admission can be very dangerous because if you ignore those, you can end up with something called a deemed admission. And a deemed admission means that the matter is admitted for all purposes and that the other side cannot bring forward evidence to contradict that. So if you mess around and you ignore requests for admission when those are served on you, you can create some major, major problems for yourself. So those are the four main types of written discovery. Again, request for disclosure, interrogatories, request for production, and request for admission. But then there's also an oral type of discovery that's used in many, many cases, and those are depositions. I could do many, many videos on depositions. I've been through hundreds of them, and they can take hours and hours, each one of them, to conduct. The longest deposition I was ever in took 3 days. So depositions can be very tedious and very long. A deposition typically is when you are sitting in a room under oath, sworn to tell the truth. There's a stenographer there taking down everything that you say, and often there's a videographer there also recording the proceedings. They're not recording it in the sense that they're filming a movie and showing everybody in the room. They're just filming you. They're just showing you talking. They're just showing you giving your testimony so that it can be recorded in that way, and so that whoever watches it later can evaluate whether or not they think you're telling the truth. There's a whole lot of information I could give you on depositions, and I will try to do that in future videos. But for today, just know that they exist. They are typically done in the fashion I said, but there can also be something called a non-stenographic deposition, which is much less expensive, and that can be done with nothing more than an iPhone. Simply putting the iPhone in front of somebody, having them swear to tell the truth, and then asking them questions that way. There are some formalities to how it needs to be done in order for it to be introduced into evidence, but there's many purposes for a deposition, and one of those is to use them in evidence in the case. Others are just to find out what the person knows, and for some other things that we'll talk about in other videos. So those are the main forms of discovery in the state of Texas. The 4 written ones that we talked about, and oral depositions. There are also other forms of discovery that you need to be aware of and that you may need to talk to your attorney about. There are requests for inspections. You can request that the court allow you to go examine property, go onto someone else's real estate and examine that. You can have what are called written depositions. There are a few other types of discovery that are out there, but generally speaking, those are all you're ever going to see in a case. The 4 we talked about that are the main written forms, oral depositions, whether stenographic or non-stenographic, requests for inspections, requests for entry on the land, or written depositions. Other than that, you're typically not going to see anything else. So that covers discovery in terms of what it is. There's a whole lot of strategy that goes into how to deal with it. There's a whole lot of strategy that goes into what you should propound to the other side, because there are certain limits on discovery in modern law. And so you can't just ask an endless amount of questions. You are limited on some of those things that we talked about. On others, you're not limited, other than as the court decides to limit you in your particular case. So you need to talk to your attorney about discovery because it's very critical and it's very dangerous to simply decide in your case that you just don't want to do any discovery because you want to save some money.